city of Richmond had a set-aside program whereby it set aside a certain percentage of the contracts with the city for minority-owned firms. And a white contractor sued and said this violated equal protection, and the Supreme Court agreed. Now, the city came in and defended its program, saying it wanted to have an affirmative action plan to make up for past discrimination. But it failed the first prong. It didn't have a compelling justification, the court said, because it had inadequate or no evidence to show that it, the city, had discriminated in the letting of its contracts in the past. Nor did it have any specific findings that there was particular discrimination in the government contracting industry, and that the city itself was actually sponsoring or propping up with financial support that discrimination. So it didn't have a compelling justification. But the law, even if it had a compelling justification, was not, the court said, well-tailored. Why? Well, first of all, it was a strict quota, a certain percentage set aside, and there was no attempt to simply use race as a factor or something like that. It was an ironclad set aside. So much percentage of the work had to go to minority contractors. In addition, the court said the program was too broad. For example, the beneficiaries under the program included groups such as, for example, Alaskan Indians, and the court said there's no evidence that Alaska Indians ever lived in Richmond, much less applied for contracts there. Moreover, there were no time limits on how long the program would last. So in order for an affirmative action program to survive, you not only have to have a compelling justification, your program also has to be well-tailored to respond to that past discrimination. So, for example, if a police department had been discriminating involving hiring in the department, it should develop a plan about hiring and not have an affirmative action plan dealing with promotion, because the past wrong was based on hiring. Moreover, in looking at affirmative action plans, the court has also said that it's going to be very attentive to, not just good tailoring, but it's also going to be very attentive and very sensitive to whether programs attempt to minimize what the court has characterized as harm to innocent whites. So, for example, a court will look more favorably on, let's say, an affirmative action hiring program than it would on a program that actually involves firing whites from their jobs in order to make way for minority candidates. So if you have an affirmative action program put in front of you for analysis, what you need to do is, first of all, make sure that you're not talking about an affirmative action program in university admissions, because at least until this point so far anyway, the court has said that good effects in that kind of a context can be enough. And so long as the program is well-tailored, race is not used as a quota but simply as a factor, that kind of program can be upheld. Of course, your professor might ask you, should Bakke be overruled? I know I've asked that question in the past. But in all other kinds of cases, to satisfy strict scrutiny, what you need is some proof that the program at issue is making up for past discrimination, and not just generally past societal discrimination, but discrimination by the particular governmental entity that wants to have the program. And second, you have to show that the law is very well tailored to make up for that past discrimination, and that it minimizes harm to innocent whites. Okay, let's talk about other forms of discrimination outside of racial discrimination. And as I said, it's fairly easy to justify a very active and searching judicial role for racially discriminatory laws, because whatever else we may know about the Equal Protection Clause, we know that historically one of the pervading purposes of the Equal Protection Clause was to outlaw racial discrimination. But once we move outside of the area of racial discrimination, it gets a little trickier. There's no historical evidence, for example, that the framers of the 14th Amendment intended to interfere with or outlaw laws that discriminated against women, or laws that discriminated against aliens or other groups other than racial groups. In fact, the framers not only didn't contemplate these matters, it may be that they accepted such kinds of discrimination as constitutionally legitimate. However, the Equal Protection Clause is not written just in terms of racial discrimination. It talks about protecting any person from a denial of equal protection. And beginning in the 1970s, the court began to identify other classifications other than race that would trigger some form of heightened review, either strict scrutiny or mid-level scrutiny. And the ones they've identified, as I said, were alienage, gender illegitimacy, and discrimination based upon a fundamental exercise of a fundamental right. Well, how did we get to add these categories? We added these categories while some other categories were rejected, like discrimination on the basis of age, or wealth, or mental retardation. Well, why some kinds of classifications and not others? Well, some of these classifications get a close look first because we think that the legislature, when it's distinguishing groups on these bases, is really acting out of prejudice or ill will against the group. For example, if the group is one where there's been an historic record of discrimination, a pervasive history of discrimination, we become suspicious that when the legislature acts against that group as a group, that they are acting out of prejudice. In fact, that's where we get this terminology, why we call some classifications suspect or quasi-suspect classes, because we suspect that prejudice is actually at work in what the legislature is doing. We also think that prejudice underlies classifications where we have laws that single out people based upon characteristics that have little or nothing to do with their ability to perform. And if these characteristics have little or nothing to do with one's ability to perform, then what are we left to conclude? Well, we're left to conclude that it's probably prejudice at work. So one reason is we think some kinds of classifications, we have a suspicion deep down that some kinds of classifications really are based on prejudice, and so we want to take a close look at these under strict scrutiny or mid-level scrutiny to smoke out the illicit reasons for acting. A second reason why the court has used heightened scrutiny for some classifications and not others is that with respect to certain classifications, the court believes that relying on those classifications compromises the values of individual justice or individual opportunity. And by that I mean we have situations where the government is really acting out of stereotypic notions about how members of particular groups behave and not based on how particular individuals behave or how they perform. And if the government legislates on the basis of stereotypical notions about how people behave because they're a member of a group, this undercuts the fundamental idea in equal protection and in our law generally that legal burden should bear some relationship to individual responsibility. This point is particularly salient in the area of gender. Laws based upon stereotypes about proper male and female roles in the society have for many, many years consigned men and women to particular futures despite their individual desires or their individual merits. So the court looks at that, and it looks at stereotypical categories that have in the past denied justice to individuals. And finally, the court also looks at something called the political process rationale. The court tends to take a close look at laws that discriminate against groups which are politically powerless or despised or devalued in the society. And the reason why we look closely at legislation against these groups is that we doubt that discrimination against such groups is likely to be rectified in the political process itself. Because ordinarily, if you don't like what's going on, if I don't like what's going on, if we don't like the laws that are adopted or whatever, you and I and everybody else generally can rely on the legislative process and the ordinary give and take of democratic politics to try to get our views adopted. Now, we don't always win, but we log roll, we form coalitions with others. We can, in effect, mix it up and have some role to play in the legislative process. But the court has said, and you may be aware of this from the famous footnote in the Caroline Products case, that sometimes you have prejudice against what are called discrete and insular minorities. That may be a special kind of condition where we doubt that the political process can be relied upon for protection. If you have groups, for example, aliens who can't even vote, where we doubt that the ordinary majoritarian political process will be available to them, where there'll be perpetual outsiders, perpetual losers in the political scheme, easy prey for picking on by the majority, then maybe those are good cases.